I'm sorry. That's correct. So that's why the pretrial credit only ran from February 20th.
Right. July 1st.
Excuse me. Thank you.
They're bringing up the physical file.
I see him coming. Maybe. Nope. Yep. Nope.
Nope.
Well, Mr. Harrison, I'm going to begin by allowing you allocution. Go ahead. You may begin. It depending upon if there's any challenges, which if neither you or I caught any, I would expect there to be one.
And we'll cross that bridge when if we come to it, Your Honor. The reason I hesitated when you asked me about were there any proposed changes is that frankly I wish there were, because it is difficult to look at a PSI where the guy has seemingly what I would describe as somewhat normal levels. I mean, his PRVs are 85, which is beyond the 75 max. But then you look down at the OB score, and it's only 15 points. Unfortunately, the primary driver of his score in this situation is his prior record, which results in the guideline that's reflected on page 1 of the SIR 8-1. And it's hard for me to wrap my brain around the fact that that is the case. Then I look at his MDOC status, and it does indicate that his sentence was 2 to 10, so 24 months to 120 months in Lake County with a potential ERD of 218 and 27. I think that the eye that we have, and I think the overall tone of the PSI in this case is that we try to butt end those. In other words, we try to achieve a concurrent sentence that has relatively the same circumstances as the current matter for which he's serving a sentence. And that again presents an interesting conundrum to the court due to the increased guidelines. In this case, due to the conviction for a C-grade felony in Lake County, which gave him another 25 points on his PRVs and really threw a monkey wrench in the whole works. It's no secret, it was no secret that this is a continuation of the Lake County case for which he stands convicted in Webster County. So in a manner of speaking, I guess what I'm asking the court to consider doing is undercutting the guidelines here based on those two, what I believe to be extenuating circumstances here. First and foremost, that the Lake County sentence arises out of the same transaction or occurrence as the case in Wexford County, mere geographical accident that he was subject to trial in 2 different locations for essentially the same act, if you will. I know I'm oversimplifying, and I don't want to inflame anybody about jurisdiction and all that kind of basic tenets of criminal jurisprudence, but it's important to me that I emphasize, at least for the record today, that I think this case presents a compelling reason to, and I'm trying to be careful in the way I say this because I don't want to make it too dramatic a point, to ignore the guidelines. Now, I don't want to load up the term ignore too much because I don't think that's really what we're doing. I just wanted to bring it to everyone's attention that ERD in 27, it's February 18th, as well as the other factors that I think call for that sort of solution by the court. Now, if we look on the second page, the R&O charge, if you will, because of his guidelines, you know, R&O is a 2-year Class G, he scores 5 to 46 on that. So that gives a little bit of understanding, at least from my perspective, of what would normally not be considered quote unquote serious or severe felonies have dire consequences when you've reached a certain level on your prior record variables. For all of those reasons, Your Honor, I would encourage the court to craft a sentence that does not unduly extend his stay in prison on the Lake County case. Thank you.
Thank you. Mr. Nate Carnes, the Chief Assistant Prosecuting Attorney, has now joined us in replace Ms. Carey. It's his file. I know he was running a bit late due to an auto issue on the way to the office. Mr. Carnes, did you have any amendments, corrections, or objections to make to the content of the report?
No, Your Honor.
Allocution on behalf of the people, then, sir?
Yes, Your Honor. The thing that sticks out the most to me with this is that the defendant was traveling up to 85 miles an hour, driving on the wrong side of the road around blind curves while there was an infant in the car. That's very disturbing to the people. And I heard most of what Mr. Harrison said. Yes, the defendant has high guidelines because of his priors, and this isn't his first plea and elude. This is extremely dangerous behavior that the defendant was found guilty of. I would urge the court to issue a sentence towards the top of the guidelines here. I'd recommend a sentence of 90 months.
Thank you. Mr. DeMambro, you have the right to make a statement if you choose to do so. I do recognize that you pled not guilty and were convicted at a trial. Is there anything you wish to say at this time, sir?
Yeah, I'm quite confused, as I have been this whole time. And it's hard for me, Your Honor. I'm trying to take your position as well as everybody else's, and I understand that there was a verdict reached. And I'm trying to be respectful to everybody, because I understand the process and I understand what's happened, and everybody has a job to do. I totally understand that. But what bothers me, okay, if I were one of them jurors that made that decision that day, okay, I would want to know everything regarding the case. Okay, I would want to know everything. And if them jurors were aware of everything regarding this case.
Here the prosecution focuses directly on the danger posed during the incident. Speeding at 85 miles per hour, driving into oncoming lanes, and doing so with an infant in the vehicle. It reframes the case not as a technical violation, but as a serious public safety threat. The prosecutor's tone signals that prior history matters less than the immediate risk created during this event.
That verdict would not have been reached because that officer is lying over and over. And I don't have to prove that. He's done it himself by his own testimony. And it was all hid from the jurors. And it's just hard for me to humbly sit here and, you know, I'm so mentally exhausted, Your Honor, that I want this to be over with, but it's hard for me to just bite the bullet and it just take something when I know it's not true. And I mean, I can say that wholeheartedly. If you look at my past, my record, I haven't done, when I've been in trouble, you know, yes, I've tried to get a good plea, but I've never taken it to this extreme. You know, this is, you know, Your Honor, I was offered a misdemeanor on this case and I didn't take it. That should tell you my sincerity in what I'm trying to tell you. And I don't know what else to say. I just, if there's any way, like I said, I understand you all have a job to do. Okay. But, you know, I'm already in my classes here. I'm already signed up for Vocational Village. I'm at a facility here that has several different vocational trades that they teach, but I'm signed up for the tree trimming job. That is the only one that guarantees you a job for when you're released, but it's in the Wayne County. But I don't care. I want away from that area anyway. So, but the point of it is, Your Honor, I'm in ASAT, which it's approximately 6 months, and then I go into the vocational trade sometime soon. My classes are all started. This is going to throw a big wrench.
As the defendant speaks, the hearing shifts from legal argument to personal struggle. He pleads that evidence was hidden, that testimony was false, and that the jury never heard the full truth. His exhaustion shows. He's simultaneously trying to accept defeat and insist on innocence. Despite his emotional sincerity, his arguments clash with the structure of sentencing, which cannot relitigate the trial.
I don't know. I feel like I'm asking too much, but then, Your Honor, you've been doing it. You know that officer's lying. You can't tell me you don't. I mean, I don't know if you've watched his other testimony, but listen and read. I mean, you guys have all been doing this the guy is lying. It's not that he's a rookie, Your Honor. He is lying. It's not that he's just inexperienced. He's experienced in lying to you. And I mean, I feel like he's been, because he had a whole different attitude in this courtroom than he did in Lake. In Lake, he thought it was funny. He laughed as he lied, smirked, and it was like intentional. But up here, he tried to act more professional and more, I feel because of the difference in the courtroom. I believe he, I don't know. I can sit and, come up with all the reasons, but I know personally that the man's not telling the truth. Okay, Your Honor. I don't know what else to say. I can't tell you, hey, I did this when it's not true. I didn't do it. And I don't, and it's hard for me. And I mean, if I just want it to be over with, if there's any way that we can give me what I have and just be over with, I'll take it as, I'm going to try, no matter what you do today, Your Honor, I'm going to try to learn from this so that I can change my life and stop being the person I was yesterday, the day before, and be a new me and get out and be successful, because I'm not a stupid person and I'm not what my PSI says. I am capable of better things than this. And, it's embarrassing for me to be sitting here in front of you, even though the circumstances and everything, it's embarrassing. And it bothers me tremendously, because I know I was raised better than what what these PSI says, I want to live, Your Honor. I've done, I can't even tell you, over 15 years, somewhere in there ever since I've been about 24, this has been my life, and I can't seem to shake it. Please have mercy on the situation, and understand that I'm being sincere. I'm not up here trying to pull your chain. You're a very smart man. I can tell it, and I can tell you're very, very good at what you do. Just take everything into consideration, please, Your Honor. I already have, everything in here is set for your ERD, which is 2/20, I think, of 27, and everything's already started. Please take that into consideration. That's all I have to say.
All right. Thank you. Before the court this morning is a 42-year-old man who has had a long history with controlled substances for about 25, 26 years. He has mixed failures and successes at rehab over the last, in and out of rehab programs for the last 25 years. The defendant's prior criminal history